Suddenly they're an adult. I can't help them anymore. I need to go and get guardianship. Whoa, 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 whoa. Wait a minute. Hi, Jeff Marsocci, the Plain English Attorney, and welcome to the video. Today we are going to talk about the 5 hidden keys to special needs estate planning. Now, in this area of law in particular, there's an awful lot of myths and half-truths and misinformation that's out there. And unfortunately, some of these things just get out there because it worked in one particular circumstance and suddenly everybody's thinking about it. But really, we've got 5 concepts to take a look at today that are going to clear up a lot about special needs estate planning for you. So hopefully, if you're in that situation where you've got a loved one, a family member, who you need to protect their benefits, but still leave an inheritance, then this video is for you. If you get a chance, please go ahead, like, subscribe. And if you think that this provided some value, consider becoming a member. We do special broadcasts just for members at a certain tier level, and it really does help us get this content out there and keep it free for you. So the very first concept is to plan your whole estate. A lot of times people end up looking at doing planning for a special needs beneficiary, saying, oh gosh, well, we need to take care of them. We need to take care of them. I heard we need this special needs trust, so we need to take care of them. And they get so hyper-focused on just helping that beneficiary that they don't realize, look, the solution is actually wrapped up in planning this whole estate, so that you're not just looking at what needs to be done for one beneficiary. You put it in the whole context of an overall plan for your estate that's going to take care of all your loved ones, not just that one beneficiary. In fact, it becomes a lot easier to look at the whole picture than just hyper-focusing on one particular beneficiary. You can make sure that their needs are being met while planning the whole estate. And that's a simple key, but it becomes one of the biggest things out there when clients come to me and they go, I need a special needs trust. And that's all they want to talk about. Well, we've got 3 kids, but one of them, they're going to have their benefits. We need to make sure they maintain their benefits. We've got to focus on just keeping their benefits. Well, wait a minute. What about the other kids? Are they disinherited? Well, no, I'm not going to disinherit. But this is what we're talking about now. No. The solution is looking at the whole picture and making sure that you're planning out the whole estate and all the different contingencies, and it just accomplishes so much more than just focusing on one thing. So that's the first big hidden key. Look at the whole picture. Second thing, if you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Second big thing, and this is for my clients with children with special needs who end up getting 18, they're becoming a legal adult, and it's like, well, wait a minute, they're becoming a legal adult. I can't just handle banking for them. I can't just make healthcare decisions for them. Suddenly they're an adult. I can't help them anymore. I need to go and get guardianship. Whoa, 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 whoa. Wait a minute. When you're talking about guardianship, you're talking about getting the state and getting a court involved in everything that's happening. You have to go to court, become a legal guardian, and now suddenly you have to keep reporting back to the court, giving progress reports, making sure that all the finances are handled exactly right. Who wants to do that? A lot of clients come to me in my law firm because they want to avoid that type of court and state and government interference. They want their plans executed, but they don't want it with the government breathing down their back. So when you have a child that has special needs, that may have benefits, or they may end up needing your help more long term, then as long as your child is actually competent, then they can execute their own durable general power of attorney. They can execute their own healthcare power of attorney, and you don't need to get a court involved. It's them executing these documents, empowering you to do these things. And it's a much, much simpler situation. But yet, I hear all the time, and this is even coming from support groups, oh, just go and get guardianship. It was easy to get the guardianship. Well, yeah, it's easy to go to court, get the guardianship, but now, on an ongoing basis, you're going to have to keep going back to that court and report on the finances and that you were a good steward. So you've just gone in and made the government your partner in helping your child long term. Nobody really wants to do that, nor should they, when there is the simple solution of your child actually executing the documents to let you keep helping them. All right, so what about the third hidden key? Well, that third hidden key is that you don't necessarily need a separate special needs trust. And this is just a simple concept that a lot of attorneys in the whole legal community just utterly fails to get across. It's that irrevocable living trust, setting up different subtrusts, is just as effective as having another document. But people assume, well, okay, I've got my trust, but I want it held in trust for my 3 kids, and one of them's a special needs beneficiary. Oh, we've got to have separate documents. No, that one document could create hundreds of trusts. It's all about the language inside the trust. So it's very typical, sticking with that same example, 3 kids, one of them is actually a beneficiary with special needs that needs to be protected, and their benefits need to be protected. Well, you can set up your revocable living trust and list, okay, well, these 2 children, they're going to get their share outright at a certain age. But if they're under that age, okay, it holds it in trust until they reach that age. But I have my beneficiary here with special needs. We need to protect that for their lifetime so they don't lose benefits, and there's some trustee supervision. The trust can just list that. So you don't normally need to have a separate special needs trust if you're the only one who's leaving an inheritance for your special needs beneficiary. And it all should be there integrated into a good, solid, revocable living trust. But here's the thing. There are a lot of revocable living trusts out there, what we call thin trusts, that they don't take care of this as a standard operating procedure within the trust. Look, when we put together good, solid, revocable living trust, the language is already in there that if a beneficiary meets that criteria, and if you just want to keep it simple, although the document doesn't, if you just want to keep this concept simple, if they're receiving government benefits and getting an inheritance would cut those benefits off, well, then the trustee does not give them that money outright. They hold it in trust. They pay for certain things here and there. They can give them enough money to work within whatever those rules are so that they don't end up losing all of their benefits just to get this inheritance. That should be a standard part of every revocable living trust, but unfortunately it isn't. Why? Well, look, you're going to have to ask the legal community about this. They're probably just falling down, or they want to, quote, upsell a separate special needs trust. That actually brings us now to the fourth hidden key of when actually do you need a separate special needs trust. There are situations. Now, let's talk about this just a little bit. If you or you and a spouse, you're leaving money to a special needs beneficiary, okay, it's got to be held in trust. You've got all of those terms. You can put that in that revocable living trust that takes care of your whole estate plan for the entire family and have that protected. But the separate special needs trust is if someone else wants to leave money to your special needs beneficiary. It's very common for grandparents to want to separately provide for a grandchild. Now, the typical estate planning setup, and I'm saying typical, not that it's 100%, it never is. The typical setup is, okay, parents want to leave money to their children in their estate plan, and if they pass on, then and only then does it go down to the grandchildren level. The grandchildren of that deceased child inherit whatever their parent would have gotten. Very typical. But a lot more often, even if that child is still alive, still capable of inheriting, the grandparents may want to do something special specifically to help that special needs grandchild up front. We don't have to worry about the parents passing on. They want to provide that. They don't want to just leave the money to their child and say, okay, well, here's some extra, just use it this way. No, they want it directly for that grandchild. That's when a separate special needs trust can come in handy. So you have that special needs trust, the grandparents can leave the money directly to it. And often it may be even the grandparent level that they're setting up this separate special needs trust. And they may even be, and this is the second part of it, gifting money over time. Sometimes just to lower a taxable estate, a family will cut the $18,000 checks because that's the gift tax limit. They're gifting it, but they can't gift it directly to that special needs child or grandchild. They have to have it set up in a trust. So, okay, that's when they would have that separate trust. And a third and less common way of doing it, although I'm seeing a little bit more of it in recent years, they're setting up that separate special needs trust to have a life insurance policy pay into that trust. Whether the trust actually owns it for estate tax reasons, that's a whole other discussion. But that's a common thing. If you're going to have that separate special needs trust, you're funding it with life insurance so that the rest of your plan can just say everything's going to the kids equally. But it's a way of acknowledging that this beneficiary may need more financial support than the rest of the family. We're going to do it through this separate trust. And now we're getting on to that fifth key. Well, what is the fifth key? Look, ABLE accounts can do some really good things, but they are not an estate plan in and of itself. No matter what the state tries to tell you, no matter what information is out there, and this is even coming somewhat from the financial community. Oh, you can set up this ABLE account and leave money for your special needs child through your ABLE account. You can gift it to this ABLE account. Well, these ABLE accounts, what exactly are they? An ABLE account is a way for a beneficiary with special needs to actually contribute money to this account to provide for their own care and needs down the road, and yet they won't go over whatever the limit is. And usually we use the Medicaid limit. They can't have more than $2,000 in their checking account. Well, if they're working, they may go over that $2,000 amount. Oh, we'll just put it into the ABLE account. Here's why this ends up often being a raw deal. If you're looking at an ABLE account as a estate plan, well, we're going to leave it in the ABLE account. It will take care of them. Yeah, but the terms of the ABLE account are stating that if there's any money left over when the child passes on, it goes back to the state. Okay, what if you leave $500,000 to your child's ABLE account and they don't spend any of it? They pass on just a few years later. Well, all that money now goes to the state. If you had set it up in your own revocable living trust or a separate special needs trust, depending on the circumstances, that $500,000 could go to other beneficiaries, the contingent beneficiaries. What are ABLE accounts good for then? Well, we've got a couple of videos out there, but an ABLE account is good for the special needs beneficiary if they are working to put their own money away, but then spend it on things that are going to increase their quality of life that go within the rules. It really doesn't make much sense at all for anyone else to put money into an ABLE account, or even for that special needs beneficiary to go without certain things to put money into that ABLE account. They should be taking advantage of the fact that it's not going to disqualify them for benefits if they're putting that money in there, but they should also be taking it out and using it within the rules as quickly as possible so that it doesn't accumulate and eventually go to the state. If you're going to do planning for a beneficiary with special needs, then do it through your own plan, not in a partnership plan with the government. It just makes better sense to do this your own way. So those are the 5 hidden keys to planning for a beneficiary with special needs. So we do have a playlist, and we do have other videos that are out there that assist and give more information on special needs. And again, I'm going to ask, please go ahead, like, subscribe, turn on the notifications, and if you got some good benefit out of this, consider becoming a member and get into these live streams. So, as I always tell my clients, please stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.